I'm glad to see a full room on this important topic. My name is Ted Ruger. I'm the Dean of Penn Law School, and I see current students, recent graduates, not so recent graduates, professors, folks from across the university, and it's good to gather to discuss this topic today. President Trump's executive order over a week ago did, as I noted in a statement of last week, it did kind of hit us where we live here at Penn Law. It did impact certain student and faculty programs, and as such, the order itself and its categorical nature is contrary to some of the core values we try to promote about bringing people from all over the world here to study and teach and exchange ideas. And we will address some of those aspects of the order on this panel today. But in some sense, as a great teaching law school, and as we're kind of working on multiple fronts to think about immigration policy in our current era, we've convened this panel in part to address some of the specific issues about the order, but also to address from a more legal or policy point of view some broader issues of immigration authority, refugee policy, executive power that have been invoked by this order and that are part of the discourse around us. On these broader questions, I know there is a diversity of opinion at the law school and in the room about the big contours of immigration policy, about the relative powers of the president, be it President Obama or President Trump, over these matters relative to, say, Congress and the courts. These are issues that will endure. These are issues that preceded the current presidential administration and will endure beyond this administration and really throughout your legal careers. This key question of how we set immigration policy, how the United States kind of interacts with the broader world, and what power we give to the executive branch and to the president specifically within our milieu of lawmaking institutions are highly relevant, of course, to this area that we'll discuss today, as almost every other area of federal policy. So there's a very immediate kind of policy consequence of this order that we'll be discussing, and then there's the broader consequences of immigration policy writ large, and kind of the legal, as befits kind of the theme of, or the title of this talk, kind of the legal institutional mix at the federal government and throughout the state and local government levels as well, that you all will participate in as lawyers. Some of you, as alumni back here, already are. And this is the way that policy change plays out. So I should note, before we get to our panel, this is one of several policy forums that we plan throughout this spring, and who knows, perhaps stretching into next fall, involving major policy shifts coming out of the new administration in Washington, but then examining how they play out within our complex legal system. So I do thank our faculty, our eminent faculty panelists for participating. I'll very briefly introduce them and then really turn the program over to them, and then return it really to you all, because we do want your input, your questions, your expertise to the extent you've thought about these issues. And so we will have a very interactive question and answer coming up after each one of our panelists will speak. Moving kind of from my immediate right further down, we have Professor Bill Burke-White, who's an expert in international law and relations. He's, in addition to his role here at Penn Law as a scholar and teacher of international law, he's the director university-wide of Penn's flagship Perry World House, and as such is intimately connected to developments around the world. Professor Burke-White also worked in the State Department when Hillary Clinton was Secretary of State, and has a deep sense of the role and connection of U.S. policy to diplomatic relations around the world, and is going to speak about that. Next along the row is Professor Howard Chang, who's the Earle Hepburn Professor of Law here at Penn, a lawyer and an economist, and brings both of those insights to the study of issues like immigration law, international trade, and similar issues. Fernando Chang-Muy is the Thomas O'Boyle Lecturer in Law, who has been among our most stalwart and popular and successful adjuncts at Penn Law for quite some time. He also teaches, he teaches refugee law and policy here. He also teaches on immigration issues at the School of Social Policy and Practice at Penn. He's had a tremendously impactful and successful career in the government and public interest and NGO world, which is too numerous to list all of his posts, but serves as commissioner of the Philadelphia Human Rights Commission, has been a legal officer with the UN and the World Health Organization, and a kind of stalwart public interest lawyer and public servant in many capacities. Jean Galbraith is assistant professor of law here at Penn, teaches contracts, but also teaches and is a leading expert in separation of powers law and the president's authority over foreign affairs. So she'll speak to this part of the process about this executive order, the kind of unilateral nature of the president's authority and how that sits in context with prior presidential regimes and our constitutional structure. And then Sarah Paoletti runs the Transnational Human Rights Clinic here at Penn Law, is practice professor of law, has a tremendous range of experience in the public interest sector and the NGO sector, has been working in ways she'll describe on issues of immigration and refugee policy deeply over the past several years, and then even in the past several weeks is kind of leading some efforts connected with Penn Law responding to this particular order. So we're very lucky to have this group of esteemed faculty, and I think we'll start out with Professor Galbraith talking about the general context of presidential power over immigration and what is this thing called an executive order, which every president issues a bunch of. What kind of law is that? And we'll start out with this.
Thank you, Ted. So my job is to set the stage with regard to presidential power at a quite high level of generality. And as we all know, our constitutional structure entrusts a great deal of power to our president. I want to suggest that for purposes of this discussion, we can think of three broad types of powers. The first are the substantive constitutional powers that the president have, and these are mostly in the foreign affairs context. So think about the power to recognize foreign nations, or the power to use force, to authorize the use of force in defense of the United States, and a series of other foreign relations powers whose contours have not been very well litigated in the court and are often contested in practice. A second category, and this is also a constitutional category for the most part to think about, is the president's power to organize and structure what goes on within the executive branch. His power to oversee and to supervise cabinet agencies and the actions that they carry out. Here again, there's always a tension between the president's constitutional powers with respect to structure and oversight and the obligations of these agencies with respect to their duties to Congress in carrying out laws. Now, a third category of power that the president has is powers that have been delegated to the president by Congress. And Congress, in passing its laws, very often passes laws that speak at a high level of generality and then instructs various executive branch actors to fill in the details or to grant waivers or something like that. And most of those laws are directed, delegating power not to the president, but rather to lower executive branch officials, cabinet officials, and heads of independent agencies, and so forth. But sometimes, and this is particularly true in the foreign affairs context, they give power to the president directly, a delegated power to the president directly, which he can then exercise. Now, with this power, of course, comes some limits on it. The first and most obvious limit is that the president actually has to have a power in order to exercise it. He can't exercise a power delegated by Congress if Congress has not actually delegated that power. And the second main set of limits come from constitutional protections with respect to individual rights and to some degree protections of federalism aimed at saving the states' rights. Now, moving to President Trump and his executive order. So what is an executive order? An executive order is basically a way in which the president uses one of those three categories of power that I just described to you. It's not the only way. Another very common way that is basically equivalent is what's called a presidential memorandum. And there are other kinds of ways the president can use those powers as well. But an executive order is a long-established process whereby the president, in a written document, sets forth his intent to use power in a certain way, and this carries the force of law. Now, since taking office, President Trump has issued 8 executive orders and 12 presidential memoranda. And this number, in and of itself, is not unusual. President Obama had issued, I believe, about 14 executive orders by the same point in his presidency. Now, what is unusual about these executive orders, and setting aside the specific substance of them, which my colleagues is going to get to with respect to immigration at least, and which is often very controversial, is two things that I want to flag for you. One unusual feature is that based on the news reporting, the process that these executive orders has gone through has been unusually insular, kept within the White House rather than involving a lot of collaboration with the agencies who have expertise in the areas that many of these executive orders relate to and who are ultimately going to be charged with carrying them out. And second, if you read these executive orders, they are unusually broad as a substantive matter. So what they'll say is something like, do X to the extent applicable law permits. And if you know something like, or don't regulate to the extent that applicable law permits you not to regulate. That's what a lot of them kind of look like. And if you know something about the applicable law, and sometimes you look at these and you say, well, applicable law doesn't permit this at all, the sentence is meaningless. And sometimes you look at it and you say, oh yeah, applicable law probably permits that. And sometimes you look at it and you say, gosh, applicable law is not very clear on this subject at all. How much actually can the president order in this respect? That's not clear. And this lack of, this breadth at the beginning, this sort of lack of specificity ex ante, means that we are going to have a lot of questions coming up ex post about what the scope of the president's power to issue these kinds of orders are. And at the front lines, we're going to see the administrative agencies have to answer and wrestle with that question. And with unusual speed, we've also seen with the immigration executive order, the courts step in to try to address and answer these questions. Now, it is not unprecedented for executive orders to get challenged in court. One of the most famous Supreme Court opinions in constitutional law, the Youngstown steel seizures cases, was a challenge to an executive order issued by President Truman. But it is fairly unusual for executive orders to come to the courts with this kind of speed and celerity. So with that, I will stop and turn it over to my colleagues.
So President Trump actually signed 3 different executive orders in late January, all of them addressing various aspects of immigration policy. But it's the third order, the one that was signed on January 27th, that provoked the most outrage and that I suspect will be the focus of much of our discussion here today. That's the order that generally suspends entry into the United States by 3 groups. First, the order suspended entry of nationals of 7 countries, which all happen to have Muslim majorities, for at least 90 days. Second, the order suspended the entry of refugees from any country for 120 days. And third, the order suspends the entry of refugees from Syria until such time as Trump decides that their admission is consistent with the national interest. And as statutory authority for these suspension of entries from specified countries, the order invokes a provision of the Immigration and Nationality Act, the INA, Section 212F, which grants rather broad powers. It says, whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Now, although that statutory language is sweeping, no president has ever invoked this provision to exclude entire nationalities as broadly as the order by President Trump does. There have been several lawsuits that have challenged its legality and have succeeded in obtaining court orders enjoining enforcement of some of its provisions. The most sweeping court order came when Judge James Robart granted the state of Washington a temporary restraining order enjoining enforcement of the entry suspensions in that executive order. And although the federal government has appealed that ruling, the US government is complying with that order, and those who would otherwise be subject to that executive order may now enter the United States, and that's for the time being. The complaints against the executive order include claims that the order is unconstitutional because it discriminates on the basis of nationality or religion. These claims face a major legal hurdle in the form of the plenary power doctrine, which gives the political branches broad powers to regulate immigration, with only deferential scrutiny by the courts. For example, in 1977, in the case of Fialo versus Bell, the Supreme Court upheld a provision of the INA that discriminated based on sex and on illegitimacy, the kind of discrimination that would normally trigger heightened judicial scrutiny in the purely domestic context. The court quoted precedent stating that, quote, in the exercise of its broad power over immigration, Congress regularly makes rules that would be unacceptable if applied to citizens. And so the courts have never struck down a discriminatory immigration restriction, and discrimination based on nationality or national origin is still common in our immigration laws. So even today, our immigration laws impose quotas based on the national origin of prospective immigrants, which mean, for example, that a native of the Philippines sponsored by a sibling who is a US citizen must wait more than 10 years longer for an immigrant visa than most other similarly situated prospective immigrants. And it is perhaps precisely in order to take advantage of the favorable precedents for nationality discrimination that you'll notice that the text of the Trump executive order carefully imposes entry restrictions based on nationality and not religion, despite what President Trump promised early on in his presidential campaign. And with that, who's next?
Let's see, Professor Chang-Muy is going to turn it over.
Sure. So first of all, thanks to Dean Ruger and Professor Sophia Lee, who is not here, for bringing us all together, and thank you all for taking time from your lives to learn a little bit more about particular groups of people who are being affected and how the executive order impacts them, their families, companies, universities, and just people's lives. So I'm going to squeeze into 5 minutes a 14-week course of refugee law. So I'm just going to talk about three things. So Professor Chang noted that on January 27th, the executive order dealt with immigrants from 7 countries and dealt with refugees. So I'm just going to talk now for 4 minutes and 45 seconds about what's a refugee. Secondly, I'll talk about how do we resolve the refugee problem. And thirdly, I'll talk about this thing of the resettlement ban, et cetera. So first of all, after World War II, governments got together and set up the UN, and the UN then set up a department called the Office of the UN High Commissioner for Refugees, and the High Commissioner invited countries to sign a treaty saying that they will give help to people in need, and we'll call them refugees. This treaty had 34 articles, and the first article defined who's a refugee, and here it is. A refugee is a person who is outside of their country of origin, is afraid, and the fear is well-founded, and they have a well-founded fear of being persecuted for 5 reasons: their race, religion, nationality, social group, or political opinion. I could have asked any one of my students to recite this because you know it by heart. So that's the definition of a refugee. There were other small details of the definition, but in 1967, the US government signed on to this treaty, And then finally, in 1980, Congress passed the 1980 Refugee Act, bringing its international legal obligations into the domestic fore. So here you have it. So our definition of a refugee is the same as the internationally accepted definition of a refugee. I'm now into class 3 of my 14-week course. So now we talk about how do we resolve the refugee problems, and there's 3 ways. The first way is if the situation that forced you out is resolved, go back home. We call that voluntarily repatriating. If you don't use the adjective voluntary, then you're being deported. So the first solution to the refugee problem is go back home voluntarily. The next solution is for you to be allowed to integrate, get help, get protection in the country you flee to. So for purposes of today, you're Iraqi, you flee to Jordan, and the best solution is for you to go back to Iraq. The next best solution is for you to be locally integrated and get asylum in Jordan. And then finally, if that's not possible for you to go back home or stay in Jordan, and some of my students here do this every spring or winter, we go to the Middle East and interview in Lebanon or in Jordan. The last solution, if you can't stay where you fled to, is to go to a third country, and that's called resettlement. So to end, what is resettlement all about in the US? So after we signed the treaty in 67 and passed the 1980 Refugee Act, we started bringing in people. We resettled them. So the Vietnamese who fled to Hong Kong or the Cambodians who fled to Thailand could not stay there. They couldn't go back home. They couldn't stay in Thailand. So we resettled them to California, to Louisiana, and that resettlement process has gone on through the years. We started with resettling 50,000, then went it up to 80,000, and last year we came up with 100,000. And typically we bring in people from the corners of the world, 10,000 from Africa, 13,000 from Central America, 30,000 from the Middle East, and President Obama, in order to help our neighbors in Europe, said let's up the number from 80 to 100,000, of which 20,000 will be reserved to people from the Middle East. So there you have the definition of a refugee. It's internationally accepted. I've shared with you the 3 durable solutions, and I've shared with you how we do the 3rd durable solution, resettlement. We bring in 100,000 people. As Professor Chang said on January 27th, the executive order said we're not going to resettle refugees for 120 days until they're vetted. And as to refugees from that part of the world called Syria, we're going to not bring in indefinitely. The vetting process, by the way, is very detailed. And again, my students who go to Lebanon or Amman, Jordan, know very well what the vetting process is. The Iraqi or the Syrian, let's say the Syrian goes to Lebanon, tells their story to the UNHCR once, tells their story to the US government yet again, tells their story to the International Organization for Migration a 3rd time, might tell their story to an NGO a 4th time, being traumatized during each telling. And then finally, the US government might take the case referred by the UNHCR, and then the vetting process starts. By this time, the Syrian is living under the expressway in Lebanon, waiting to be cleared, and then when they're cleared, maybe 2 years have passed, then they come. What I'm getting to is that there's a deep vetting process that goes on, and so refugees from the Middle East, Somalia, Sudan, China, Ethiopia are all vetted, and yet there seems to be a feeling that there's not enough vetting, hence the executive order which said we're going to wait 120 days before anybody comes, and we're going to not bring in anyone from Syria indefinitely until we're sure that they're not terrorists. So there you have the refugee definition, the 3 durable solutions, and how resettlement has been working to date.
Thank you. Professor Paoletti.
Thank you. So I want to reiterate the thanks to all of you for being here and your interest in this topic and this issue. I feel like the January 27th executive order is sort of starkly calls into question our values as a country in immigration and what we value in our immigration system and how we think about that. And so this is an important dialogue. I was asked to talk about the legal challenges, but I'll start by saying that the resolution of the legal cases will not end those challenges and will not sort of resolve the question of values as to where we place immigration within our country and what we value in our immigration system, as we know from many, many years of failed attempts at comprehensive immigration reform. So we've heard a little bit about the challenge to the most recent executive order, the January 27th executive order, the 7-country travel ban, the Muslim ban, the national security order, however you want to label it. I did a quick check that Lawfare is tracking. There are 24 open cases pending on this executive order alone. There are 13 additional cases that have been closed. And they fall into, I would say, sort of 3 general categories of cases. There are individual habeas petitions for the individuals who are detained at the airport on arrival, right? The individuals who are in flight, the individuals who are stuck in transit trying to get to the United States, who had purchased their tickets, who the order went into effect immediately. They were on an airplane. They arrived at our borders. They were detained. And lawyers and community members and others sort of sprung into action. And we had a stay out of New York, a stay out of Boston. We had successful litigation here in Philadelphia as well to get many of those families ultimately released. And then that led to sort of the stay out of Boston, which was a temporary enjoining through February 3rd, I think. And then we saw the Washington State case, which was mentioned earlier. There are the organizational challenges with organizations like the ACLU and others. Immigrant rights groups are taking this on in terms of discrimination, substantive due process, and procedural due process. And states are getting involved. And so right now, all eyes are on the state of Washington. All eyes are actually going to be on San Francisco at 6 o'clock when they'll be streaming live the oral arguments for the Ninth Circuit appeal of the district court stay out of Washington State. There are issues in the litigation that were alluded to, partly because of the broad breadth of plenary powers, the broad breadth of discretion that has been afforded the executive branch in the enforcement of immigration. And so thinking then first about who are the plaintiffs and who has standing, who was harmed directly. Can states, can institutions or organizations stand in parens patriae in the litigation? Are we going to prioritize procedural due process over substantive due process? And how do we go about proving religious discrimination when, as was pointed out, right? The executive order was very carefully written. Although I'll point out, while the executive order specifies countries, and it doesn't actually list the countries directly in the executive order, you have to go to other places to figure out what those 7 countries are. They are Muslim majority countries with an exception carved out in the executive order for religious minorities. And so when you look at that and put that in the context of the campaign rhetoric, I think you find yourself closer to being able to make out a discrimination claim than you might otherwise. But I also want to just sort of talk about some of the other forms of legal challenges that are being presented that folks are thinking about. And I say this because we've got the stays, we've got the sort of big class action litigations going on that folks are focused on, but at the same time, other people who practice immigration law, who are trying to make decisions about whether to get on a plane, who are trying to make decisions about whether to file a petition or not, whether to go forward with their asylum application, are just trying to figure out what this all means. Stories are coming out from airports about comments that are being made and things that are being said by Customs and Border Patrol to individuals going through the process. And so FOIA is our friend, right? This is going to be sort of the new era of FOIA litigation to help find out what actually is going on. How are policies being carried out? What do they mean and what is their impact? And then just fighting for the right to access to counsel. So I mentioned sort of the success the weekend of January 28th that lawyers had on behalf of their clients in the habeas petitions and in other cases. But there was a family out of Philadelphia that was deported. They got here and they were deported before their lawyers could get to them. And so a lot of attention has been spent sort of talking in a law school and talking to law students. I sort of feel compelled to talk about sort of the important role that lawyers have played, that lawyers can play, and ensuring access to justice and some due process as we figure out what these executive orders mean, whether they're constitutional and how they play out moving forward. So we saw law school clinics, we saw the ACLU, the National Immigration Law Center, we saw just private attorneys, legal services attorneys here from Hyas and other places in Philadelphia. But lawyers don't operate alone. And so lawyers operate in conjunction with the community organizations that told them what was going on, that got them in the door. Lawyers operated alongside massive movements of people coming out to support the litigation, to provide the pressure and right? So over the course of the weekend, we went from legal permanent residents were being subject to the ban to, oh, well, no, legal permanent residents aren't subject to the ban. That wasn't necessarily the result of litigation alone. We then saw another clarifying statement that, in fact, those individuals who had SIV visas, which are special immigrant visas for individuals who were working for our military in Iraq as interpreters, or in other forms as contractors for our US military, well, in fact, they aren't subject to the ban either. Again, that's not necessarily the result of litigation, but that's the result of a coordinated advocacy movement taken in hand with litigation, but public pressure and a recognition of what does this mean, and again, what are we valuing in our immigration system? I also just want to call attention to the fact that while we spend a lot of attention has been spent, and I think rightly so, because it is sort of the most stark executive order, the executive order of January 27th, there were the two other executive orders of January 25th. And so when the January 27th order came down, I was still trying to figure out what the January 25th orders were going to mean for some of our clients and others in terms of expedited removal, due process, detention. We have had the Third Circuit rule that individuals who have arrived in this country who have not yet passed a credible fear interview, so they're subject to a process called expedited removal before they even get to make their claim for asylum, are not subject to habeas protections. And so individuals who have pending, want to seek asylum, who are trying to seek asylum here in Berks, Pennsylvania, just 90 minutes away from here, women and children who've been detained for over a year are not entitled to habeas protection, according to the Third Circuit. So there's a lot going on in the immigration arena. There's a lot to figure out. The litigation plays a role in it, and it forces a conversation. And so as sort of folks were running to the airports and we were fielding calls from folks asking how they could get involved, and I was thinking about the plenary power doctrine. I was thinking about an article that I assigned to my students by Jules Lebel called Losers, Fools, and Prophets, about sort of the role that litigation plays in broader conversations and enforcing conversations about what are our values in immigration and in all areas that affect the lives of the people in our communities.
Thank you. Professor Burke-White.
So I'm going to come at this to some degree as a foreign policy person as much as a lawyer, because I feel like I can't talk on immigration law the way some of my colleagues can, but I can certainly put this in a foreign policy perspective. Yesterday I was in Moscow, Russia, in meetings at the Russian Ministry of Foreign Affairs. And the fact that Trump's executive order was the thing they wanted to talk about tells us something. Partly it tells us that this has been one of the most destabilizing 2 weeks in U.S. foreign policy that we've perhaps ever seen. Destabilizing in both the sense of significant changes in longstanding approaches. Usually the difference between a Democratic and a Republican administration in foreign policy is about, 2 degrees on the compass. And for most of the last, 50 or 250 years, welcoming people to the United States has been part of America's basic foreign policy. And that has destabilized the Russians, among others, trying to figure out what this means. The other reason that it's destabilizing is because, as we've heard, it's very unclear what it actually means, and it changes every time a clarifying statement is made. From the Russian perspective, however, part of what they're trying to figure out is, does this mean that the United States is no longer focused on human rights as a core value of its foreign policy? The concern about terror and potential terror attacks is really now the driving force of U.S. foreign policy. And I will say some of the Russians I met with were quite happy about that and saw this as a great way for U.S.-Russian relations to improve. Others, the ones who I would call friends, were very concerned about what that meant. Last week, I was in London and Amsterdam giving talks at the European Council on Foreign Relations. And this is the kind of country, the UK, where this change, this executive order, is actually very problematic for our relationship. Theresa May finds herself in a political pickle of the first order. She has invited Donald Trump to come on a state visit to the UK, but the British Parliament has said that because of this executive order, he will not be welcome to speak to Parliament. Trying to figure out how to navigate the relationship with our closest ally is going to be very, very hard. And then you look at the countries affected by the ban themselves. Iraq, Iran. These are countries with which we have very delicate and very challenging relations. On one hand, this executive order will please some of those governments because, guess what? We may no longer be taking the citizens that want to leave them. On the other hand, it is the very populations in these countries that the United States needs to work with in order to promote change within those countries. So I think this has put the U.S. in an unusual and difficult political challenge in our foreign policy, where suddenly the issue of whether these individual countries are banned is the topic of conversation in every U.S. diplomatic discussion around the world. That's probably not where the Trump administration intended to find its diplomacy 2 weeks in. But I think it will continue to dominate bilateral relations, both with the countries affected by the ban and those that are not directly affected by it, but are trying to figure out what it means for the vector of U.S. foreign policy. The second thing I want to mention, which has already been talked about a little bit, is the extraordinarily unusual nature of the drafting of this ban. And we see the problems of that in all of the lack of clarity of what the order actually means. When I worked for Secretary Clinton at the State Department, and sorry, I wear my politics on my sleeve and I can't hide it, I worked for her, and you can sort of guess where I am on some of this. I was fortunate enough to get to sign off on executive orders on behalf of the Secretary of State. No one at the State Department had seen this. No one of the country desk officers of the impacted countries, or the countries might care, were briefed in advance so they could try to explain it to our other, to foreign governments around the world. I think even if you think there are legitimate reasons to impose this ban, diplomacy says you've got to brief other countries on this in advance and engage them so it doesn't have the kind of ramifications that it is already having. And the fact that it was so narrowly circulated is actually going to make the legal challenges easier in many ways because of the problems it brought into it, but has made U.S. diplomacy even harder. The final thing I want to say on the diplomatic side, and this is true at the beginning of any administration, is that the ranks of the U.S., of the State Department and U.S. diplomats are at the senior level massively understaffed because on January 20th, rightfully so, Obama's political appointees left. And Trump's political appointees either have not been confirmed, Tillerson now has, but below that haven't been confirmed, or haven't yet been able, to even been nominated. We need people in in these positions to try to explain this and to work with countries around the world as this gets implemented if it continues to do so. The last thing I want to say is the United States is the hardest country in the world to enter. Getting a visa, which some of you have done, is really, really hard. Getting screened is really, really hard. And that's probably a good thing in many ways. But it means that saying we're going to have a 120-day pause on Syrians and 90 days on others till we implement extreme vetting is hard to get one's mind around. What could that actually mean in practice? The only thing I think it can mean is that you're really not going to give anybody visas because it is already so hard to get here. And it's sort of a dirty secret about how hard it is to get here, because on one hand, the United States has lived, even under President Obama, in a world of rhetoric of we are an open country that wants to welcome people from all around the world as refugees or asylum seekers, yet had a very low quota to get in and made it very difficult to get here. And so we have to face a fundamental question of whether Democrat or Republican administration presiding, do we want to be the place that, in the sort of words of George Washington, which I'm going to get a little bit wrong, the bosom of America is open to people from all nations, whether rich or poor, or do we want to be a place that says that, you know, keeping our borders closed is the way to be secure? Neither the Obama administration nor the Trump administration has done much in terms of advancing what George Washington said, and I think this is a moment where we have to think about where this fits in our broader foreign policy, how important a value is to this, and then how do we achieve it in a way that is legal, keeps us safe, and also furthers our diplomatic goals around the world.
Thank you. Let me ask one question and encourage any of you who have comments or questions to. We've got 2 microphones back there. We'll open it up soon. Thank you to all the panelists. We heard a lot about the White House and the executive order and the traditions of the executive branch. We heard about the courts and the litigation. We heard a bit less about Congress, but you mentioned there is Democratic and Republican critique of this executive order. I wonder if you, maybe Bill, speaking from your perspective at the State Department, what are some things that Congress did or that you've seen in the past or could do to kind of hem in executive authority? And Gene, if you want to address that a bit as well with your historical perspective.
So on the Congress point, I think it was very interesting that we heard from the Republican leadership that they weren't excited about passing new legislation if if the order does not survive the courts. And I think it's useful for Congress to say that and to make clear that there's not a great enthusiasm for this on either side of the aisle. In terms of what Congress can do from my seat at the State Department, we have an Assistant Secretary of State for Population, Refugees, and Migration who oversees the congressional budget authorization that is used to support things like the International Organization on Migration. Advertisement here. Perry Worldhouse is delighted that we are hosting as a resident visiting fellow. The woman until two weeks ago served as that Assistant Secretary for Population, Refugees, and Migration. You can come here or speak at some point. But Congress can put more funding there if they want to. That money is used not just for resettlement in the United States, but to help asylum seekers and refugees, whether they're in third countries or trying to leave dangerous areas. There's more I think Congress can do even where we do close our own borders. But I'll tell you, it's extremely hard if you're a diplomat to convince another country to let people in when you're not letting them in yourself.
So when I think of checks on presidential power, I think of the courts, executive branch agencies, and particularly civil servants, other countries in their pushback, both diplomatically and through international law channels, and Congress. And I sometimes do put Congress forth, and this is an occasion in which I do, that we are not going to see any congressional statutes in the immediate future pushing back on President Trump because they would not be able to override his veto. However, we do see significant soft law powers coming into play, and probably the most effective check that Congress brings to this process at the moment is the fact that if President Trump becomes more unpopular as a result of this order and irritates various members of Congress, their interest in doing things that President Trump wants to do in other spheres, Obamacare, and then there's a very long list that follows from that, goes down a bit. Hard to quantify what that bit is, but this is the time, this is the honeymoon, right? President Trump needs to use the honeymoon to get an affirmative agenda through Congress. And it looks like the divorce is going to come a little faster than usual if this keeps up.
So again, thank you to all of my colleagues. It really for a multifaceted treatment of this. I know that you could all share more, and we'd love to bring the audience into the conversation. There are 2 microphones. If yes.
I just have a question because I
Can you no? Well, I was just going to say, for anybody who speaks, would you just please identify yourself? Let us know who you are. Okay.
I just had a clarification question about the law on the I understand that immigrants and refugees aren't entitled to the same constitutional protection as citizens, but I wasn't clear as to whether there are any settled constitutional limitations on the regulation or discrimination, if you will, against refugees. Like, are there any constitutional restrictions that are settled, and your limitations on power? And does that change if it's an executive order versus a statute?
Fernando, do you want to?
Well, the Immigration Act, the immigration law, has reasons to keep people out and reasons to deport people, not admit you and deport you. I'm not sure if I understand your question, Sharon, but say you are Iraqi and you go next door to Lebanon and you tell your story 5 times and you're recognized as a refugee. If there's something that renders you inadmissible, you will not be allowed. And one of the grounds of inadmission is terrorism.
My question was, like, can you discriminate on the basis of religion? Like, are there constitutional limits? Could you pass a law saying no Muslims?
That is an open question.
Ask us tomorrow.
So that's not settled. That was my question.
No. This is going to be precedent-setting litigation.
We've lived in this uneasy compromise for a very long time where you have cases on the books for the 19th century that say basically, yes, you can discriminate on any of these things with respect to people who haven't come into the country. And there's been an uneasy compromise since because we haven't seen in the post sort of Brown era the kind of aggressive moves by the executive branch.
This is the Korematsu is still good law. The Chinese exclusion case is still good law. This has been a sort of hypothetical I've been posing in my immigration law class year after year as this wacky idea that will, just to provoke conversation. But our new president is testing the limits, the very outer limits of the power of the political branches to discriminate in our immigration laws.
Though the flip side, by the way, applies. As you've heard, one could say I have a well-founded fear of persecution based on my religion. I'm Jehovah's Witness in a majority non-Jehovah's Witness place, and if you can prove persecution because of your religion, that might help you win the case to come in. By the way, just for those of you who haven't taken our courses, so to pass the refugee test, you have to show well-founded fear of persecution based on one of the 5 grounds. If you're telling the story outside and you win the test, the standard, your name is refugee. If you're already physically in the US, you're a foreign student, you don't want to go back to Iran or wherever, and you pass the test, your name is asylee, but the standard is the same. There are 80,000 or 100,000 numbers from overseas to come in. There's no quota. Once you're in the US, the administration hasn't said, administrative law judges or immigration law judges can only grant X number of asylum cases. There's no quota, as opposed to the overseas there is.
And I would say Guantanamo is an interesting parallel here, in that you saw what the Bush administration did with respect to Guantanamo was to take some very, immediately post-World War II cases, say these are still good law, and we can do all of this. And the courts pushed back, but didn't push back to the extent that the advocates of closing Guantanamo would have wanted to. So it'll be interesting to see the extent to which we see that kind of structural story replicated in this context.
I would just say, as the least expert person up here, I can be a little more bold, Sharon, in my prediction, which is just that I think courts across the board, judges would strike down a categorical Muslim ban. And I think one bit of evidence to that is, as hasty and sloppy as the drafting of this order was, whoever drafted it, was it Sessions, was it Giuliani, there's lots of stories, was pretty careful not to list Muslims facially. So I do think a facial Muslim ban would be struck down.
Watched Judge Robart's questioning was on television, and
Right.
that was exactly what he got. But I just realized I wasn't clear on the law at all. So
But if a court strikes it down on the basis that this is discrimination based on religion, it will be a new precedent.
And I
There
guess
is no
I-
case
yeah.
doing that.
I would say if the court upholds it, if ultimately the courts uphold it, they will do so by saying, oh, it's not a Muslim ban, see, there's some other differentiating factor, and then president's authority over immigration. Yes, sir.
Hi, my name's Jonah. First, a comment. So I actually had lunch today with the chief litigant of the two Syrian families, and happily, that litigation was successful, and they flew into JFK a few days ago and are now with their families in Allentown. So that's the good news, anyway. My question was, though, so I'm a practicing immigration attorney. I've got sort of a list of clients where I may be, filing my own actions in district court. So I'd like to hear a little bit about sort of application of the rational basis test to these particular orders, because if you sort of listening to what Judge Robert was saying to the U.S. or questioning the U.S. attorney in that case, he seemed to be applying the rational basis of excluding these people on national security grounds. So ask the U.S. attorney, can you name one person from any of these listed countries who's committed a major terrorist act? And the U.S. attorney could not. However, in the District of Massachusetts decision, where the judge declined to do a permanent stay, he seemed to be applying the rational basis test more to the language of the actual executive orders, which was, we need to do these, these 90-day, these 60-day, these 120-day pauses, just because we can't walk and chew gum at the same time, and we have to rewrite our policies, and we can't be admitting people while we're rewriting our policies. So I'd love to hear some comments on, what does that get applied to, and then also how much can you take into account sort of the outside verbiage? I mean, I guess to put it shortly, do I have to figure out a blue book citation to a presidential tweet, like when he says,
Yes.
people are flowing in massive numbers, shut this down? So I know that's a lot, but anyway, if you could comment on all of that, I would love it. Thank you.
Take it away.
Well, yeah, I think that's precisely the sort of test. Courts normally assume that it's the rational basis test that applies to immigration restrictions like this. And what was interesting about Judge Robarts is how seriously he was applying that test and actually asking for evidence, facts to support the claim that this travel ban has a rational basis. That's perhaps more aggressive than sometimes we've seen in this sort of litigation when you're talking about an immigration restriction. But I think that suggests that if that test is taken seriously, it's possible that this order could flunk that test. We have a situation where a president, given his statements on the campaign trail, his statements in public, his playing with facts, raises the question of whether the sort of deference that courts have shown in the past to the political branches is really such a great idea. Our president, with this executive order, is providing an important occasion to revisit that plenary power doctrine and ask whether Congress really wants to give that much, or I'm sorry, the courts really want to give that much of a blank check to this president. We have a president who reminds us that the executive may not be basing policy on facts. Maybe the executive is basing policy on prejudice. And if that's a real possibility, do the courts want to perhaps take a more active role in applying some real judicial scrutiny, acting as a check on what the executive does. And what happens in this litigation is important, not just because of what's contained in this order, but because of all the executive orders that might follow in the future. Because the president is testing what he can do here. And the executive order itself, if you look at it, envisions future bans. What it says they're doing this for is to determine what information the United States needs to determine that those seeking entry are not security or public safety threats. And the Secretary of Homeland Security is supposed to develop a list of countries that don't provide adequate information. And so the order is raising the threat of future proclamations banning entries from countries that fail to provide the information that's requested. And that raises the possibility of a ban of indefinite duration that might be even broader than the suspensions that were announced on January 27th. There's an element in the order for adding countries to this list. And so if the courts give a blank check to the president, he may well use it to ban more and more countries, more and more nationalities. So the courts really need to take seriously what exactly they're prepared to countenance, because the authority in 212F is very broad, and if this is okay, then why not permanent bans? Why not bans from all Muslim majority countries? What kind of scrutiny are we going to see? And that's what makes this litigation quite so important.
If I could make reference to what something Bill Burke-White said. So this has big political implications, and history repeats itself. In the 1990s, the United States government was pushing back Haitians who left Haiti. They tried to come to the United States seeking help, and we pushed them back. That was that. So then when the United States government criticized the government of India for pushing back Tibetans and Nepalese, India replied, well, how dare you criticize us for pushing back Nepalese or Tibetans when you yourself are pushing back Haitians? So there's going to be a domino effect. And again, it's just history repeating itself. So it's not just thinking about us, but thinking of the diplomatic ramifications that this policy could have with other countries.
Mm-hmm. Yes, sir.
Hi, my name is Alex Fortmuller. I'm a Wharton student, so thank you for hosting this. I'm from California, and talking about immigration, there's a bigger sort of question mark looming of what happens to all the people that are already here. California has sort of put in place becoming a sanctuary state. The Trump administration has threatened withdrawing federal funding. And so I'd love to just hear the panel's opinion overall on the process there and what can be done and so on. Thank you.
So I'll take that. So first, back to the question that was just before, I think this is a moment to dust off basic con law cases like City of Cleburne, honestly, and bring immigration and the kind of rational basis with teeth sort of idea together. On the sanctuary states and cities question, when I alluded in my opening remarks to executive order provisions where they said, do X to the extent allowed by applicable law, and I read it and think, but applicable law doesn't allow that. Sanctuary states, I think, and cities is an example where there's very broad language in the executive order saying take all funding away from sanctuary cities and sanctuary states. It is the purpose to declare that these places are terrible and awful, basically. That's sort of the language of the statute. And yet, if you think about the precedents in a case called Prince, which says basically that you can't commandeer state and local officials to do what to carry out federal law, combined with the line of cases that Ted knows much better than me, the sort of health law in the healthcare and other contexts, saying you can't condition federal funding on states and cities undertaking certain action unless that funding is reasonably tied already to the kind of action sphere in which they're operating. It's a case called Dole, and we saw a little bit of that in the Obamacare Sebelius case. Combined with that, I think we're going to see there's some federal funding that's going to end up being at issue, but it's a much narrower swath than one might imagine, and it's going to be left to litigation and negotiation to work out exactly how wide or narrow that is, but my suspicion is it's going to end up being a not too big cut.
Yeah, so I'll just say, this is part of one of the January 25th orders, right? One of the January 25th executive orders. But I think it highlights a complete misconception about what sanctuary cities and sanctuary municipalities, sanctuary campuses are. The word sanctuary conveys a myth that there is harboring of individuals and that the cities and states are going to, ensure that nobody is ever deported. But in fact, that's not what it is. And it's just saying that we are not going to voluntarily turn our people over. We're not going to voluntarily hold our people on ICE detainers unless there's a warrant. We're not going to have somebody sitting in jail for 2, 3, 4, 5 days while we wait for for ICE to show up and take them into custody. They're not saying that when ICE has a legitimate basis to enforce their federal immigration powers to instigate a removal proceeding, that they're going to stand in the way of that. And so I think this is a situation where the rhetoric has created an executive order that's just sort of fed into the confusion about what sanctuary cities are. Sanctuary cities are communities coming together, police unions coming together with the municipal governments and saying, in order to ensure our community's safety, our public health, our public security, we need to treat all residents of our municipality the same and cannot have our residents afraid to step forward and seek the police, to report to the police, to take their kids to the hospital, whatever it is. But the January 25th order does talk about punishment of sanctuary cities, a reinvigoration of the 287G agreements, which are the cooperation agreements, which we saw towards the end of the Bush administration took a real surge. Secured communities, the so-called secured communities, which was terminated because it was deemed sort of ineffective. They're pushing people underground as opposed to allowing for communities to come out into the open and interact and not be in hiding. And when you have people in hiding, you have problems that flow from that, more from ensuring that folks can participate in their community. Again, not saying that the cities are going to interfere with the federal government's power and authority to execute the immigration laws.
Just one more general comment, and I do see you up there, is just that this implicates principles of federalism and diffusion of power and variation throughout our very pluralist legal system in the U.S. And as such, and you look back 50 years, by the way, the party that has occupied the White House, it's down to the year. I guess it's going to change next year, but down to the year right now, it's equal, Democrat, Republican, which is a way of saying these questions of federalism I like to think about, and it poses a challenge to all of us, including me, in my writing and thinking about consistency in the application of these general principles, like diffusion of authority and devolution of power. Many of you in the room are bigger fans of federalism now than you were 6 months ago. And I should say, I mean, many of us up here, it's worth interrogating, when we think about neutral legal principles and what the optimal allocation of power is in our pluralist structure, we should kind of hold ourselves to account as the occupant of the White House changes. But that's, that we're very much connected to that.
So just building on that, right? The key piece of the litigation is the question of standing, right? The litigation now is the question of standing. And if you look back not so long ago, the state of Texas challenged the policy guidance. It was not even an executive order creating deferred action for parents of Americans and the extended program of deferred action for child arrivals. And Texas's argument for standing was it was going to cost them a little more money to issue driver's licenses to these individuals. And the Fifth Circuit granted standing And then obviously it went to a tie to the Supreme Court, so that case was never really heard on the merits. So if we want to sort of look at the arguments on standing and the cost to states and institutions to impose the ban and what that means, I think we've got a pretty good foot on standing.
Yes.
Hi, I'm Allison Kowalski. I'm a 3L here at the law school. Thank you to all of our panelists for a very interesting discussion. My question is related to something that Professor Galbraith said about civil society and civil servants acting as one of the checks on presidential power. And in the past 2 weeks, we've seen the firing of Sally Yates. We've seen dissent memos circulating in the State Department, and we've seen Sean Spicer say in a press conference, if you don't like it, get out. So I was just kind of wanted to pose to the panel, in this very unique climate, what do you think a check on presidential power from the employees of an executive agency would look like?
Bill, do you want to start with?
Yeah, you know how frustrating it was when we went and told, like, the Foreign Service officers do something, and they're like, well, we'll schedule 18 coffee meetings and discussions, and then maybe you'll be done being Secretary of State by the time we actually get around to doing it. It was sort of Ted's point from a minute ago. The bureaucracy...
And law's government's model, but yes, right.
The bureaucracy is extremely good at resisting things they don't want to do, because they have one thing on their side, which is time. Sally Yates is a slightly different example, because she actually was in a politically appointed position, just held over, and you could say she should have resigned as opposed to refusing to implement. But I do think that within the structures of bureaucracy, there's lots of ways to decide how quickly to move something forward, and I think you're going to see that. The Trump doesn't have the power to fire those career people as opposed to presidential appointees, even if they're career people serving in presidentially appointed positions, which was the case of some of the senior officials at the State Department. I think the other thing to bear in mind with sort of the folks that are the career government officials is, when do they want to risk their job, and when do they want to risk sort of their credibility, if not their job? And so deciding when to push back is going to be a hard choice for people, and they're going to have to sort of see, when is the right moment to do that. But I do think you'll see some slow-rolling, positions. There was one tweet that I saw yesterday that worried me a great deal, which was when Trump tweeted that I have ordered the Department of Homeland Security to exercise even more extreme scrutiny, which, it depends on if you're working there, you see that tweet. What is that? Is that an order from the president in defiance of the court stay? Is it telling people, oh, just be a little more, difficult in those interviews? I don't know. But, hopefully people will, who work in government will say, first of all, I have to follow the law, and this is what the law is. And then secondly, use discretion a little bit within the parameters of what's acceptable as to how to interpret things and how to move it forward.
I have to say that I have, and maybe Sarah does too, former students who are working as asylum officers in the U.S. or refugee officers outside the U.S. They're GS 15, 16, earning $70,000, $80,000 a year. Not bad. And Allison, to answer your question, what they could do is exactly what Bill said. They could apply the law fairly. They could remember the courses that we took in refugee law and continue to interview people, determine that they are refugees if they meet the definition, and just be voices from the inside, either in the United States as asylum officers or overseas as refugee processors, and give people a chance to have a better life.
And I would say, I think the clarifying statements that we saw on legal permanent residence and on the SI visa I mentioned earlier was partly the result of a broad backlash in the public, but also the work of civil servants, right? Clarifying how can we limit this in ways that aren't quite so damaging.
Mm-hmm. Yes.
Yes, thanks, and it dovetails perfectly. I have a commentary from the practice side of it, which is I have several clients now I'm representing from some of the affected countries, and we've been on the phone for the past 10 days with everyone we can get to, with USCIS, State Department, embassies, and it seems that they're all very scared. And I think that's because this executive order turned victim of persecution into possible terrorist in one sweep of the pen. And my impression has been that they are terrified to do anything and be the one who lets that person in. So, you know, there's some sort of retribution that they're really terrified of. My actual question was about, on the actual countries who are included in the executive order, we've heard that they may expand that out to non-Muslim countries. And how does that affect the legal challenges to it if that sort of religious test goes away?
Howard? Yeah.
That would help them deflect the claim that this is really about religion. On the other hand, if you think what's going on is a disguised ban on religion, this is just part of the disguise that's being added, and a court could say, you're not fooling us. We know what you're really trying to do. Your purpose was made clear earlier on. It's made clear on some of the statements you've made on television. So it would be a fact that might change things, but might not.
Yes.
My name is Sharda, and I'm a research fellow here, but perhaps more pertinently for this question, I'm also an immigrant that entered this country and saw the chaos, entered this country last weekend and saw some of the chaos around the implementation of the order and experienced firsthand what extreme scrutiny looks like. So the question that I have is in particular about the kinds of repercussions this has on consulates around the world that are like facing or having to process visas about for immigrants that are entering the US, because what we have been hearing in terms of advice is that visas have been stalled across the board in consulates around, and this poses challenges to people that are not on the list of the countries that are on the order, legal immigrants that have that are entering the US are currently considering renewing their term and are caught in limbo. So what is the position on this, and where does that come from? Is there a legal rule or a regulation that states that?
I'm sorry, you're telling me that people from countries not included in the travel ban have been affected exactly how?
Okay, I am from India, which is not a country on that list. And I was held at Iceland for what they called secondary screening, but not really secondary screening because I've been through that. And it was an hour-long question-answer session on my travel record and over and above like all of the regular pat-downs and all of the things that you go through when you go through.
Well, there's nothing in the
And
executive
it
order.
was-
I
that,
can
yes.
comment on a couple pieces of this. First of all, U.S. consulates around the world were already massively understaffed in terms of the number of visa interviews that they need to do. To the degree that you are increasing either the number of interviews needed, and there is mention in the ban, in the executive order of rescinding some of the interview waiver programs that had previously existed, that increases the demand on consulates. And then if you say, oh, and make them extreme, you may actually, even further lengthen the delay time to get interviews for visas. And I think we are seeing increases in delays, how far out you have to go to schedule a visa interview. It is also quite possible that even in non-listed countries, nationals of those countries may be applying for visas because they have a legal reason to be in the country, that isn't affected, but where they're applying from. So I do think this is going to be a concern. I'm organizing a major international conference with people from 50 countries around the world next year, in 2 months, and we're telling people to go schedule interviews, and they're getting, the first date we can get you an interview is after the conference that's in April. So I think we are seeing increase in delays. How long that's going to take, whether that smooths out once sort of some of the chaos is sorted, is still to be determined.
And I'll say some of the chaos has been around treatment of dual nationals. What do we do with dual nationals? What passport are people traveling on? Not your situation, but again, but the added layer of all of this is the airline industry, right? The airline industry is getting involved in enforcing our immigration laws because they don't want to be responsible for that person who they've brought to the United States who's then not let into the country. And so I was part of a sign-on letter to the airlines saying, this is what the executive order is. We think it violates international law, and, think twice about what you're doing and what obligations you have consistent with the laws of your own country. But airlines are in very tricky positions, and so you've got that added layer of airlines who are not immigration lawyers, who are probably not reading the executive order and, trying to figure it out just like the rest of us are, engaged in a level of screening and interference, not issuing plane tickets and not letting people board the plane. And so that just sort of adds to the chaos that we're seeing.
So I think we have 3 people in the queue, 1 here, 2 over there, and so we have time if with a brief question and just 1 brief answer from the panel for each. Go, yeah.
Hi, I'm Lisa. I'm also a Wharton student. Thank you for hosting us. And my question is, I believe that the Bush and the Obama administrations, and probably many other past administrations, have also passed immigration bans. Can you please explain how they are different from this ban as to them being passed more peacefully, perhaps, and what the details of them were?
Does one of you want to take that briefly?
Well, I'm not sure which bans you're talking about. Certainly, past presidents have invoked Section 212F, but the bans that they've imposed are much narrower. They're officials of the...
What about President Obama's the ban on Iraqis that's been in the news or in the rhetoric?
It wasn't a ban on Iraqis. It was increased procedures in terms of screening that slowed down the admissions of Iraqis. And so the references to a ban on Iraqis is just inaccurate.
Okay.
So I think at a broader level, I think presidents will do much better in the popular opinion and also with the courts if it looks like what they're doing is predicated on facts rather than alternative facts. And so this is the challenge that the Trump administration is facing.
Great. Yes.
Hi, my name is Ilan Rosenberg. I'm a lecturer here, but I'm also the president of HIAS. And I have a very serious concern, both as president of HIAS and as a lawyer generally, which is that the field in which these executive orders, or in which this particular executive order was issued, I am concerned lends itself to a very interesting challenge to the judiciary, which is, let me just say up front, I am not terribly optimistic about the success of the case that's currently before the Ninth Circuit, which hopefully will go back to Washington District Court. But the fact of the matter is that the executive retains a tremendous amount of discretion when it comes to spending funds and staffing both. Let me say specifically the State Department. So our job is to resettle refugees. There's only 2 of our agencies in Philadelphia that are doing this. Now, right now, we're doing nothing. We had budgeted for 250 refugees this year. So far this year, we've already resettled 100, but no more coming in as far as we're concerned. And our biggest concern is, even if the action is successful, even if the executive order is declared unconstitutional or unlawful, one way or the other, this does not in any way compel the executive to actually reinstate those programs or, from a practical standpoint, effectively neuter them by removing all staffing or not spending the money. So this is a situation where I, as a lawyer and as a board member of a nonprofit, have never found myself. But frankly, it presents a lot of concerns. And other than just venting today, I wanted to present to you. There were perhaps a similar situation in the context of Brown v. Board of Education and compelling school districts to integrate. But I don't think it quite applies here, and I don't know that the judiciary actually has the tools to enforce its own orders or even a ruling declaring all of this unconstitutional.
Yeah, I'll just respond briefly. I agree with you, and I don't think if you're invoking the Brown story, it's not a happy story, and that took decades. So it really will. The judiciary clearly has the power, and it may be presented as a real question to enforce the negative orders, and this came to a head apparently in some airports around the country, where there's a ban in place to direct official action. But when it does come to spending money, putting resources to the problem, it's not going to happen from the judges. It's got to be, maybe Congress, maybe state and local governments. Again, California is stepping up and they have the resources to step up. Unclear whether Pennsylvania has the excess resources or the political will to do so. So let's, I think I saw Akbar, okay, well, and yes, one last question then, thanks.
Akbar, are you not gonna, no? Okay. So Professor Paoletti, you mentioned some of the FOIA litigation that might come out in the future, and you also mentioned the ways that the airlines have been dealing with this, so I was curious, in terms of non-compliance, whether it be by airlines in airports abroad or by CBP agents domestically, what avenues are there to challenging the refusal to comply with stays and continuing to implement the executive order?
Well, this goes fundamentally to whether we're a country of laws or not, and at what degree we respect the judiciary and when the judiciary acts. And so, the statement out of the Department of Homeland Security has been, we will respect the stays, right? We will respect the court orders. And then it is a question of vigilance and diligence in making sure that that happens, and if it doesn't happen, holding them to account, right? Do you want to then be holding the federal government in contempt of court? I mean,
So maybe, so we end with that question.
But that's where we end. But we can't do it, right? I mean, we saw this even under the Obama administration, under the Bush administration, on issues of immigrant detention. We've been asking for detailed numbers on who's detained for how long, under what auspices, and the basis for the detention and the forms of relief being asked. Unless you've got that data, it's hard to know how to challenge what's going on. And so I think it's a matter of sort of paying attention and being diligent and holding people to account.
Yeah, I wonder if we could shift gears for 30 seconds to nonprofit corporate law. And this is in reference to our colleague from HIAS. So for those of you who don't have the time to go to the airport, if you don't want to get involved in litigation or help somebody and host somebody in your house, one thing you could do is make a tax-deductible donation to HIAS or Nationality Services Center. It's the least thing you could do, and it's tax-deductible. So, that's an action that we can all take.
Terrific. This could clearly go on longer. It's a crucial topic. I will say this is one of what we think will be a series of policy discussions about the policy changes that are coming. I'm really glad to see people from other parts of campus, from the local bar, alumni, so we'll keep you posted on topics about healthcare and environmental law and other things that emerge. Thank you so much to our panelists.